Child Abduction Legislation Miscellaneous Amendment Bill 2013. I call the meeting to order. The first item is the election of chairman. Any nominations? There are only 3 of us. We should have 8 members, but there are only 3 here. Well, we need one nominator and 1 seconder. You nominate Mr. Dennis Kwok, and I second. Mr. Kwok, you will be the chairman.
Let's
invite the administration to join us. I don't think we need a deputy chairman.
Yeah, thank you. 廖女士，謝女士。係歡迎各位官員。
Welcome. Perhaps I will ask Ms. Leung to take us through the paper. This is our first meeting. Today is the Child Abduction Legislation Miscellaneous Amendment Bill 2013. The purpose is to amend CACO, the Child Abduction and Custody Ordinance, Cap 512, and to implement the recommendations of the LRC on international parental child abduction, so that the Convention of the Civil Aspects of International Child Abduction, the Convention, can be better implemented. Starting from a while back, the LRC, the Law Reform Commission, has released a number of reports on child issues, and parental child abduction is one of the issues. And usually when the relationship between 2 parents breaks down and one of them, often in the face of a court order that he is unhappy with, takes the law into his own hands and absconds with the child to another jurisdiction. At present, the Hague Convention provides an effective international mechanism to secure the prompt and safe return of children who have been wrongfully removed from one contracting state to another, to ensure that the rights of custody and access under the law of the state are effectively respected. And in Hong Kong, Hong Kong is a member of the Hague Convention, and the convention is given force by the CACO. And if the child is removed by one parent or family members, there will be measures put in place. And we understand that the children will go through a hard time in such times. The recommendations of the report is to prevent parental child abduction. And in relation to local legislation, Well, we have also taken reference from overseas legislation. There are 6 recommendations from the LRC. 6 of them, 4 of them relates to prevention of removal of child. Let's say, for example, legislation, and also to empower the relevant law enforcement agencies to hold the child and to return the child. And there are also a number of recommendations of the LRC. That is, in relation to disclosure of whereabouts and return of the child. In October 2009, we gave a response to the LRC saying that we accept the recommendations of the report, and through legislation we will revise the relevant provisions. There will be additional provisions stating that without the consent of a parent, the child should not be removed by anyone. And the court of first instance will be empowered to make orders such as a location order, recovery order, and also an order to stop the child from being removed. We will also empower the police and immigration officers to hold a child when the child is suspected to be removed from the jurisdiction, and the child will be taken to a safe place. We are also aware that in the report there are some observations in relation to the implementation of the Hague Convention. We have taken into consideration these observations. They are in relation to difficulties when handling Hague Convention cases. So in relation, we will implement revisions to the matrimonial causes ordinance, the judicial proceedings regulation of reports ordinance, and the High Court ordinance, the High Court rules. We make recommendations that the central authority, that is Secretary for Justice and the court, to more effectively deal with abduction cases. Say, for example, court of first instance will allow both parents to be present in court hearings, and the S4J will be empowered to make a written report in abduction cases. The LRC has conducted a consultation in relation to child custody and access. We think that this is in line with public expectation and will be supported by the public. In 2010 September, there was a meeting of the panel on social welfare services, and in general they support our views. This will further strengthen the prevention of child adoption. This is in the best interest of children involved. And I thank members for joining this Bills Committee, and I look forward to hearing from you views to improve the bill. Anyone who would like to supplement? Not at this stage. Any questions? Our Legal Services Division sent a letter to Mr. on the 5th of September. It's a detailed letter setting out the various questions related to the law. Now perhaps you give us a brief outline of the letter. Well, these are in relation to the individual provisions. I will explain them in detail when we go through the clause by clause. In general, the additional section 15, the new section 15, is one of the provisions to be added. That is, a person cannot remove a child out of Hong Kong without the consent of the other parent or an appropriate party. Although it is stipulated explicitly that it is forbidden, but the removal of a child is not set as a criminal offense. that attracts a penalty. Perhaps the administration will give us a detailed response. Under new sections 15 to 18, there is no provision of empowering the court to change, to vary, suspend, or discharge orders. And apart from the new section 18, there are no new procedures put in place. We would like to hear from the administration about that. Another main point is Section 20. This is not an empowering section to the court, but it empowers the immigration officers and police officers to detain a child who is reasonably suspected to be removed. That is, if the police suspects that the child, the removal of a child will breach the relevant provisions, then the child can be detained. It involves a lot of legal issues, mainly the Convention on the Rights of the Child. That is, the arrest, detention, or imprisonment of a child shall be done in a certain way. And the Basic Law provides that Hong Kong residents shall have freedom of movement. And the Hong Kong Bill of Rights also provides for freedom of movement and freedom to choose his residence. So we have to make sure that these do not contravene all the provisions I've just outlined. The rights of the child also provides that the detention of a child should be the last resort. That is, the administration has the duty under the convention to consider whether to use detention to achieve the goal. And have they considered other alternatives? If they have, why weren't they adopted? And for the rest is in relation to details, that is, whether arrest by force will be involved in the detention, because the child may be 16 or 17. When the child resists arrest, does the police officer have the power to use force to detain the child? The rest are details.
Most of the issues raised by the legal advisor are related to the law or human rights. I believe with the paper is quite long, I believe the administration needs some time to prepare a written reply. Are you prepared to do that? Certainly, Chairman will provide a detailed paper in response. At this stage, do members have any questions? Mr. Tam Yu Chong, since we have time, I'd like to ask a few questions related to the electrical brief. I'd like the administration to clarify on these points. But of course, it can be done by writing. First, in relation to the Hague Convention, I'd like to know whether it applies to the three places across the straits. The Hague Convention is not enforceable on the mainland yet. And it applies to places within the same country. So, and therefore, it doesn't. I mean, it doesn't apply to places within the same country, and therefore, in order to ensure smooth operation of the convention, it is important to prevent the abduction of a child away from Hong Kong. So, for adoption cases involving Hong Kong and the mainland, I believe the legislation can be helpful. So while China is not yet a party state, the legislation will help. For instance, if the abduction takes place in Taiwan or the mainland, the legislation will still be useful. Well, we are talking about the abduction of a child without the consent of another parent away from Hong Kong. Of course, there is very frequent exchange between Hong Kong and the mainland, and a parent intends to take the child away from Hong Kong, and if the other parent feels that there is such a possibility, he can apply for an order from the court. The court or the immigration department will be notified, and the child can then be stopped from leaving Hong Kong and returned to the parent with custody right, so that we can stop such abduction at source. All right, at the border point, even before the child leaves the territory, you can stop that. Once he is away from Hong Kong, the law cannot be invoked. Right, we have to use other means. After notification of the court order, will it be really effective in stopping the removal of child from Hong Kong without the consent of one parent? I'd like to know how long can it take effect after notification? Do you get my point? I think you are talking about if a father or a mother chooses to inform the immigration order the existence of such an order. Now, first we need a written notification to the immigration department. And as soon as the immigration department receives the notification, the information of the parent and also the child can be uploaded to their computer system, and colleagues at border points can then be alerted when they process the clearance. If the child is found to be on the list, then it can be detained at once, because the time can be very short. By the time the paper or the court, the order reaches the immigration department, the child might have already left. The immigration department will upload the information to our computer system as soon as possible. This can be done very expeditiously, but if the parent takes some time to notify the department after he has got the order, then we'll not be able to stop the child in time. But we will maintain very close communication with the court, hoping to shorten the time in between as far as possible. Since there are no other colleagues, two members have raised their hands. All right, then I'll wait for my second turn. Dr. Fernando Zhang, a point related to Mr. Tam's question. If a parent has applied for a court order to prohibit the removal of the child from Hong Kong. Now, if both parents have applied for such an order governing the other party, Party A perhaps has taken the child, promising to take him to play somewhere, and Party B has not yet received the information. Party B can be the mother or the father. What can he do under the law? Of course, the other parent is prohibited from removing the child. After notification to the immigration department, something can be done. But for the other parent, where can he turn to for help? If one parent has taken or removed the child out of Hong Kong, what support does the other parents have in terms of under the law as well as supportive measures. Assuming that the child is really removed from Hong Kong, what support can we offer for the remaining parent? What safeguard? A safeguard for the parent who's remaining. If I may try. We do not have any provision to allow either parent to stop or detain a child when the other parent is trying to remove it from Hong Kong. Assuming that one parent is trying to do that. Now, assuming that the relationship between the parents has broken down and they're already fighting for custodial right, the custody order does require one parent to inform the other party of his intention to remove the child from Hong Kong, while the other party cannot stop the child from going. So if one parent would like to remove a child from Hong Kong and the Immigration Department is aware of custody order, currently we will just stop the child and the department will not detain the child. In other words, the parent who intends to remove the child can still do it again, or even hide him somewhere in Hong Kong so that he will not be able to meet the parent with the custodial right. So the LLC would like to improve our legal provisions so that when this happens, the child can be stopped and detained by Immigration Department and returned to the parent with the custodial right. The biggest difference between the proposed legislation and the current practice is we can in future detain the child and return him to the parent with the right to keep him and to ensure that the removal would not happen again. I don't think you have answered my question very directly. Anyway, we will have a bill to amend sharing of custodial right. That is joint custody. I like to know the objective of your amendment. Assuming that the legislation on joint custody is amended, what will be the impact on this current bill? So the parent with the custodial right hasn't given his consent, the child cannot be removed by another parent, and the department will have the right to keep the child for a while for return to the parent with the right. When there is joint custody, both parents have the right. So what will be the law like in the future? Well, this is already happening even now because the court can order joint custody as well. Not all parents will apply for such an order. A parent will only do so if he feels that it's quite likely for his child to be removed by the other parent. So he has to apply for a court order and then inform the Immigration Department before we can keep the child. So whether it is a joint custody or not, the principle is just the same. When a court order is in force, when A applies for the order to stop B from removing the child, by the same token, B can also apply for the same. So The proposals here will not be affected by the recommendations contained in the report on joint custody. So, joint custody. The parent has to return the child to the parent who has applied for the order. All right, he has to return the child to the parent who has not adopted the child. All right, even if the order is granted by the court and the other party has successfully removed the child from Hong Kong, the remaining parent in Hong Kong, assuming he has the custodial right, he can be the father or mother or just a guardian. What channels does he have to seek a redress or to follow up? Now, if we are talking about international child abduction, we can invoke the Hague Convention, assuming that the child has been abducted to a party state of the convention. Then, under the proceedings in the convention, we can then try to locate the child and have him back.
So the party will have to go to the court and make an application under the Hague Convention for another order, requesting the abducting parent to come back with the child. Sorry, speakers off mic. Well, the DOJ is the central authority of the Hague Convention. When this happens, the left behind parent may make an application to the central authority, that is the DOJ, without having to go to the court. All that parent has to do is to fill in some information in the application, say, for example, where the child has gone and the particulars of the child and the abducting parent, to which country they have gone, and the place of residence or place of stay in the other place, and then we will contact the opposite number of the other country and give the information to the other central authority, which will use local legislation to initiate the surrender procedure. So this is a service provided by the DOJ, yes. Mr. Raymond Wong. Well, just now the chairman mentioned that the Legal Service Division has raised a number of questions. And I think these are areas of concern for members, in particular Section 20. I hope the administration will give us some specific answers, because these are concrete issues. We're talking about a power to detain, which was not there in the past. And the detainees are children, and they have rights. And I think this is the most important part. We need some clear information. And in relation to making the removal of a child an offense, there is no detailed provision in the law. We would like to get more information. And now we have the Bills Committee. You will have to give us all the information during clause by clause. A follow-up on what Mr. Tam Yu Chung has asked. Is China a contracting state? China is not yet a contracting state. So this is in relation to contracting states to the Hague Convention. And you said that there aren't too many cases of abduction to the mainland. But every year there are about 700 cases when parents have breached court orders by removing the child out of Hong Kong. But very often, the abducting parent will only know about these orders when they are stopped at the border control point. So, well, perhaps they think that it is not against the law because they did not even know about an order. And you said that the proposed measures can better deal with such cases. Can you give me more information? In relation to the figures, the number of cases we are aware of, they are in relation to existing provisions prohibiting a parent from removing a child without the consent of the other parent. The immigration give us the figure of cases that they know. And based on the experience of our officers during school holidays in December, April, there are more such cases. And very often, parents just take their children for a holiday without knowing that they need to get a consent from the other parent. So we're talking about those cases. So with the with the legislative amendment, the parent would have breached the law. Under the amendment, only when a parent has applied for an order and the immigration is notified. That yes, you can stop and detain, but the abducting parent has not breached any law, right? We will supply written information in relation to criminalizing this act. Well, you have to refer to the recommendations of the LRC. The law enforcement agencies are the police and the immigration, and if they don't know about the purpose of the law, then they were not in a position to effectively enforce the law. Well, will the police or the immigration be accused of abusing their power? Or what about when the child is 16 or 17? The child can resist arrest because the child may want to leave with the abducting parent. And are you going to charge the child with resisting a police officer? That is another problem. So there should be some remedies in the law. And to supplement what Mr. Tam said, well, it doesn't even apply to Taiwan because Taiwan is part of China. So if the child is taken to China, what can the left behind parent do? Well, if the child is taken to the mainland, then something can be done. Even to Macau, something can be done. What about Taiwan? Well, Taiwan is its own sovereignty. So what if the child is removed to Taiwan? What can be done? As I've explained, there are two parts. Out of these 6 recommendations, 4 of them target removal of a child, and 2 of them targets the Hague Convention. If it's under the Hague Convention, then we have to fulfill our duties and act accordingly. If the child thinks that there is a high likelihood that the child will be removed, there is another avenue for the parent to make an application to the court for the child to be returned should this happen. So this is an improvement to the existing situation. Yes, even if the place is not a contracting party, you won't be able to take the child there because you'll be stopped at the border control. But what about those who have gone past customs It's perfectly possible, because the immigration might have not been aware of that, and there may be a time lag. The information has yet to reach the immigration and the child has already left. Don't tell me that it will not happen. What if the child is taken to Taiwan? I don't think you may not be able to answer my question because you are from the Labor and Welfare Bureau, so you may not be able to answer my question. But my question is a very valid one. When I ask the relevant department to think about this, why wouldn't you think that this would be a problem? You said that as soon as there is an order, the immigration will receive the order and the child will be stopped. But you can't guarantee that the child will not have left already. So if it's another contracting state, then we can use the Hague Convention. There is mutual legal assistance. So there is a mechanism for the child to be found. But what if the child is taken to Taiwan? I'm not trying to be difficult, and you need to give me some answers. You now cannot answer my question, but this is a very important question. And I hope that the administration will be able to give me an answer. Mr. Tam Yu Chong, I would like to get some clarification. In the proposed provisions, it says that there is the Children's Scotland Act 1995, and it's similar to bracket 3 and 6. So I'd like to know the two bracket 3 and bracket 6 of the Scotland Act. What are these provisions? I have the Children's Scotland Act 1995. There are subclause. There's section 2 bracket 3 and 6 states that no one has the right to remove a child whose habitual residence is Scotland to the UK, and the child cannot stay outside UK unless there is consent. And subsection 6 states that talks about parties who can give consent. I think that they are in relation to parties that can exercise rights over the child. And these are referred to in section 2 bracket 1. Say, for example, those living with the child are in contact with the child and a legal representative of the child. And in the new section 15 subsection 3 and 4, they are based on the Scotland Act. So the Children's Scotland Act is similar to ours. That's why you have mirrored it. Yes, this is based on the recommendation of the LRC. They think that section bracket 2 and 3 are of reference value to us. So paragraph 6A, small Roman 3, it says this section would also extend to any child of the family. What is it specifically about? Any child of the family. is of a wider scope than the normal meaning of a child. Recommendation 1 of the LRC is to expand the scope to any child of the family. This is under the definition of the relevant provision. It's not limited to just children born out of wedlock. So the scope is wider than children born under a wedlock. So children born out of wedlock, children born to a marriage, and children that are in a family who has remarried. Mr. Ronnie Tong. When I see the bill, I can't find the definition of child. In the new section 15, C1547. So it says out the new 15, that is in relation to an application of a prohibition order. There is a definition. So those under 18. 15 subsection 1, the definition of child includes a child of the family as defined by section 2 subsection 1 of the Matrimonial Proceedings and Property Ordinance, Cap 192. And subsection 2 of 15 states that it applies to a child who is under the age of 18. Where can we find the definition of children of a family? Do they refer to children born to a marriage enacted in Hong Kong, or children born to a marriage recognized by Hong Kong courts?
Thank you, Mr. Tong, for your question. Cap 512, child abduction legislation, does not contain a statutory definition for a child. Cap 512 mainly deals with Hague Convention cases, and provisions applicable are found in our annex, and they applies to a child who is under the age of 16. I think you should consider whether the definitions should be clarified, because this is a related issue. Usually under the law, marriage recognized by a local court, and we call it a judgment in rem, and it has to be recognized by all courts all over the world. This is different from a judgment in persona, which will only apply to that person. And judgment in rem should be recognized by all courts over the world, and assistance should be given as far as possible. Now, if the two are party states, of course, there is another obligation on one party to enforce the provisions. Now, we don't have to consider how effective our law is in other jurisdictions. For instance, some colleagues would like to know what if it happens in Taiwan. To a certain extent, we do accept or recognize judgments or acts of Taiwan or the mainland. Recently, there is a CFA case where a Taiwan bankruptcy order was recognized and implemented. Although under the PLC's definition, Taiwan is actually an unlawful jurisdiction. Don't mind me in saying so. Anyway, it's not recognized. It's not recognized by PRC. However, well, under the arrangement is for fugitives to be surrendered. Well, it's my time. Well, I already said, please don't mind me. This is my time. Under the law, or PRC's law, Taiwan is an unlawful jurisdiction. And Hong Kong is part of China, and therefore, in principle, Hong Kong doesn't recognize Taiwan as a lawful jurisdiction. However, our court usually recognizes a de facto jurisdiction. So, in the CSA's recent judgment, we used that basis to accept a court order from Taiwan. Perhaps we don't need such knowledge for scrutinizing this bill, but perhaps this piece of information may assist members in understanding the situation and in implementing the bill. So can you give us an information paper? Tell us whether Taiwan also recognizes our orders and enforces them. While we are part of China, we are two different jurisdictions. The mainland cannot enforce court orders of Hong Kong, though they respect them. At times, they may be able to enforce our court orders, but not always the case. So the situation is also limited in Taiwan. However, that should not affect this bill. We can only do our part. So please give us a paper and tell us under what circumstances Taiwan and the mainland will recognize and enforce a court order of Hong Kong. Please prepare a paper for us and tell us whether we need a definition for a child, because the marriage is not recognized in Hong Kong. What if it is a same-sex marriage and the wedding took place in New York, and then the couple has adopted a child? I'd like to know whether the law will apply to that scenario, because there are such things in society. And the definition of a child is important. We have to define whether it should be under the age of 16 or 18. If you ask me, I feel that 16 is quite a child who is 16 is quite big, and you have to respect his wish. He may not agree to be returned to his mother or father, and we do have the Rights of the Child Convention, and we must not breach that convention as well. So the point about legality of a marriage and also the age of a child, you might want to think twice about these points. Ms. Lam? Well, yes, we will think about the issues raised by Mr. Ronnie Tong. Yes, please do so. Mr. Wong Yok-man, I'd like to respond to Ronnie Tong's remarks. Now, he is a veteran barrister, and he said that PRC doesn't recognize Taiwan as a lawful jurisdiction. I asked him to present evidence. Well, the PRC represents China in the United Nations. It doesn't accept the Republic of China. So, for exchanges between the two places, Well, they do so through the consensus achieved under 9.2. So they have agreements for surrender of fugitives where there is none in between Hong Kong and Taiwan and mainland and Hong Kong. So, Mr. Ronnie Tong, if you have committed offense and fled to Taiwan, there is no way we can have you extradited back. Now, if a PRC doesn't recognize the Taiwan as a jurisdiction, how can that be done? Well, you asked me not to mind. In fact, I am a Hong Konger. I'm not a Taiwanese. And PRC and China has got so much exchange, and they have escalated to senior government officials addressing each other's title. Well, at APEC. Well, one addressed the other as Director Zheng, and the other addressed the other party as Director Wang. So, in fact, their recognition has escalated to a new height. So, I'm talking about politics, you're talking about law, and at this point of jurisdiction, I think there is a major problem. I've never seen such a term in any document or instruments of PRC or in the court. PRC doesn't recognize Taiwan as a country, as a must, but politically this is not the case. Well, this is an irrelevant point, but I hope that the officials here will not mind. I myself, of course, will not mind. All right, Dr. Fernando Zhang. I'd like to ask the administration, how come the bill is presented to the council so late? Because the LLC proposed such amendments in 2002. And of course, there were many years of discussions before that. So the past 11 years, there might have many such cases. So according to your estimate, on average, there have been 700 cases of a parent breaching a court order. So what happened in the past decade? How come the bill is introduced to the councils at so late a stage? A very good question. I'm also interested. Well, the 4 LLC reports were published in between 2002 and 2005. And this report, together with 2 reports under the portfolio of the Labour and Welfare Bureau, were subject of discussion with the Home Affairs or Welfare Services Panel. And then in 2012, we completed the bill on child custody ordinance. And in 2012, we also worked on the 4th report. That is the report on child custody and access. We did a public consultation last year, and in July, we reported to the Welfare Services Panel our way forward, and that we're going to adopt the recommendations of the report, and we're now working on the drafting of the bill. So we followed the order, and this bill is mainly on the report on international parental child abduction. But this report was published by LRC in 2002, which is 11 years ago. Your amendments are based on the recommendations made 11 years ago. Of course, you beat around the bushes and told us that a lot of other things were happening, but you have not answered my question directly. The proposed amendments were submitted by the LRC in 2002, of course, to the government. So what has caused the administration to wait for 11 years before legislative proposals are presented? Well, as I said, in 2009, we completed our consideration of all 4 reports. And we set out the government's position, and we have not stopped our work since 2009. Dr. Zhang, I don't think she's able to answer your question. In fact, many LLC reports have been sitting there with no follow-up. I think we should be grateful that there is a bill here on this report. There are many other LLC reports pending. The HLS panel will follow on this. I'm sure the officials have heard your question. Have you got other points? No, I just find it regrettable. Yes, indeed, regrettable. What about the wish of the child? If the child wants to leave Hong Kong, how does the law deal with it currently? Nobody takes him out of Hong Kong, but he wants to leave. Well, this bill targets the scenario when he is abducted. If he's able to express his wish, and there is also a close exchange between Hong Kong and the mainland, and this bill will not take care of that scenario. All right, you are talking about those under the age of 16. What's your definition? Under the age of 18, if he wants to leave, how are you going to tell whether he does it on his own volition or he's being taken out? Can I ask my colleague from the IM Immigration Department to answer? Thank you. Usually at our border points, control points, our colleagues would consider the age of the child concerned. If the child is already 17 or 18, and if he's on the list, our colleague will ask whether he is accompanied by anybody. If the answer is yes, is going on his own because he can have his own autonomy, so we cannot stop him from going because it is not a case of abduction. If the child, however, is just 10 or 8 years old, we have to find out the accompanying adult, because under such circumstances it's impossible that he's going on his own. Well, if he's going to the mainland, how come it is impossible? He has got the home visit permit. Well, a travel document. Now, if he is over 11 years old, he can has a child ID card. For those who are below 11 years old, he has to got a return permit. And going to other places, a passport is required.
But
there is no objective criteria. Say for 10 or 8, it's very obvious. For 16, 17, then they can take care of themselves. What about 12 or 13? It will be difficult for you to tell whether they are allowed to leave on their own. Perhaps someone has coached the child, and in a way it is abduction. How do you decide? We look at the reasonableness. For a child, if they have the ability and they have the freedom of movement, it's difficult for us to determine that the child is coached to leave Hong Kong. Under existing provisions, if there are suspicions of abduction, and if we have sufficient reasons to doubt that, to suspect that, then the child can be detained. Otherwise, we don't have the power to do so. I've had a lot of questions, most of them legal questions, and I believe that a lot of groups, especially child rights groups, the Law Society, the Bar Association, and parent groups will have a lot of views to express. Do we need a public hearing to invite deputations to come to talk to us? Mr. Ronnie Tong. Yes, I agree, but I would like to ask a question first. The family court, if there is a custody order made. Is there an age limit? What about 16, 17? I know that there is one for children who are 10 or 11. I don't do any family law, so I don't really know what happens. So any regulations or rules? Usually when it comes to custody order, the effect is till the child is 18. So for a child 13, 16 is still under a custody order. But now a child 12 or 13 years old can be really tall, and you can't tell that he's only 12. But you can show, but you can look at their ID documents. But they will have travel documents, even for children 11 years old. So you look at the reasonableness. Several years ago, there was a child who has gone missing because he left to go to Shenzhen and he disappeared. And the child was only 11 or so. So you will not be able to tell. How will you be able to enforce the law? I am concerned. We have to look at the situation, and it is difficult. And if we have suspicions that it's an abduction, we will have the power to stop the child or detain the child, and that is the only circumstance. And if it's a mature child who can clearly tell us that he is going to Shenzhen for just a couple of hours to join his friends, and we have not really any reasons to suspect that it's an abduction case, then there is nothing we can do, because it's not the law to stop us from stopping the child from leaving Hong Kong. It's just to stop abduction. Then will a child be allowed to make representation? Say, for example, just to stop the child, and the child will tell the parents, or the court will have to tell the court or the mother that actually I'm not being abducted. I'm just going there to have fun. It's not fair to the child. Is there a chance for the child to make himself clear? Well, if there are suspicions that it's an abduction case, then the child will be detained and stopped. In other words, of course, we will have to look at reasonableness. The immigration has already replied that in general, when a child go through customs on his own, he will be asked what he is going to do, and is he accompanied by anyone, when relevant questions. If the child insists on leaving Hong Kong on his own under the existing provision, well, there is no power to detain that child. So it depends whether the child is eloquent. So perhaps some objective factors, say it's a 13-year-old to UK boarding school. Well, I believe that the immigration will ask the child to produce some documents showing that the child is studying in a certain school. Well, if you agree that we need a public hearing and to invite submissions, then we will try to find a slot, and we will invite all relevant bodies and the public for the public hearing. Any other business? No? Well then, that's it. Thank you very much.
Thank you.